A very, very good evening to all of you. A very, very good evening to all of you, friends. So, friends, we are back with this very important session called Special Events Legal General Knowledge. In this session, I plan to discuss with you a very, very important judgment that was delivered by the Honorable Supreme Court of India this week itself. So, in the last week, the Supreme Court of India has directed certain rules that are required to be followed in a bail petition. Now, why has this happened? Why has the judges directed certain prerequisites in a bail petition that is to be filed in the Supreme Court? I'm going to talk about the history. I'm going to talk about the details of the case. But before that, BYJU'S exam prep brings to you an all India mock test, open mock test for CLAT examination. The CLAT examination mock test has already begun yesterday. Between 22nd and 28th of January, you can sit for this examination. It's free of cost. So go to the description box below. You will find a link over there. Click on the link and register yourself for the All India Open Law Entrance Test. For other law entrance examination, we have already conducted the Maharashtra CET mock. We have already conducted the Jamia mock, and we are conducting the SLAT mock. So get a taste of what these kind of question paper looks like. BYJU'S exam prep also brings to you unlock your 3-day free trial access to all our courses. So go to the description box below. You will also find a link over there. Click on the link and you can access 3-day free trial access to all our courses. Hurry up. And in case you are preparing yourself for other law entrance examination like SLAT, Maharashtra CET and Jamia, and you wish to talk to one of our counselors, go to the description box below. You will find a link for that also. So all the links are given in the description box below. Do not forget to go through them. But coming to this very important session wherein we are going to discuss about the direction of the Supreme Court. In a landmark judgment, the Supreme Court has directed certain prerequisites that are to be followed while a person has filed a bail petition in the Supreme Court. Now, what made the court direct such things? What is the history? Now, over the years, what the Supreme Court has noticed is simply this, that a number of people who are denied bail by the trial court as well as by the High Court, they come to the Supreme Court. They have a right to do so under the provisions of law. But there are certain instances where litigants who are wanting a bail to be granted by the Supreme Court are playing hide and seek with the court. Now, what do you mean by hide and seek with the court? They are not coming up with all factual details. They are hiding certain facts from the courts. And because of this reason, the Supreme Court in this very important judgment has directed that from now onwards, all bail petitions which are filed in the Supreme Court is bound to disclose a number of important things. And this particular judgment might come in your CLAT examination. And henceforth, I want each and every one of you to take note of this very, very important judgment. Okay. So guys, let's get started. Let's get started. Okay, fantastic. Now, the Supreme Court of India, way back in Chandra Shashi, the Supreme Court was faced with a situation where an attempt was made to deceive the court. So litigants are coming to the court and is trying to deceive the judges, the court, interfere with the administration of justice. So in Chandra Shashi versus Anil Kumar Verma, the Supreme Court dealt with a situation where an attempt was made by a litigant to deceive the court and thereby interfere with the administration of the justice system. Now, of course, in that particular case, in Chandra Shashi's case, the Supreme Court held the litigant who came with dirty hands, who came to deceive the court, and the court understood that an attempt was made to deceive the court, held that litigant guilty of contempt of court. So the Supreme Court in Chandra Shashi's case, wherein the facts of the case was such that the party who came to the court with the intention to deceive the court and had attempted to deceive the court. So the Supreme Court held that person guilty of contempt of court. Now, in that particular judgment, the Supreme Court held, and I quote, the stream of administration of justice has to remain unpolluted so that purity of court's atmosphere may be vital to the organ of the state. Polluters of judicial firmament are therefore required to be taken care of the maintaining the sublimity of court's environment and also to enable it to administer justice fairly and to the satisfaction of all concerned. So here we see the Supreme Court lamenting that certain litigants are coming to the court and is polluting the streams, the rivers of justice. Now, the people who are polluting this judicial stream of the state are doing it with certain things in their mind, at the back of their mind. Now, what is expected out of a litigant? So, when you go to the court, you tell the facts of your case and you also tell the judge the particular law which is involved in the case and leave it to the judges to decide whichever side they wish to as per the law. But certain people are coming to the court and is polluting the streams of justice. They are doing it intentionally to get a favorable order. Now, can a litigant be allowed to take undue advantage of the Supreme Court just to get a judgment in their favor? Now, that cannot be done. The streams of justice cannot be polluted. Anyone who takes recourse of fraud, deflects in the course of judicial proceeding, or if anything is done with oblique motive, the same interferes with the administration of justice. Such persons are required to be properly dealt with, not only to punish them for the wrong done, but also to deter or to stop others from indulging in similar acts, which shakes the faith of people in the administration of justice. So, People must have faith in the judicial administration. Now, people are coming with half-baked facts, half telling the truth, certain lies, and because of the judges believing what the lawyers are saying, they are giving certain orders. That might not be the justice system. This, now certain people, कुछ लोग झूठ मूठ लिख के सुप्रीम कोर्ट के सामने कुछ भी बोल देते हैं और इसके लिए जज लोग कभी कभार शायद जस्टिस के साथ खड़े नहीं हो पा रहे हैं. The fault is not with the judges, not with the justice delivery system, but it is with those litigants who are coming to pollute the administration of justice. Is that clear? Again, in K.D. Sharma versus Steel Authority of India, the Supreme Court said, if the applicant does not disclose all material facts fairly, truly, but states them in a distorted manner and misleads the court. So the court is talking about manner in which certain litigants are coming to the court with distorted facts, not telling every aspect of the case, thereby trying to mislead the court. So when lawyers say certain things to the judge believes the lawyers. Now, one should also understand that the lawyer is also not at fault because the client comes to the lawyer and tell the facts. At max, the lawyers might see the papers and verify them. But if certain facts, certain papers are hidden by the clients themselves, then I personally believe it is not the fault of the lawyers. It is the fault of those people who are trying to mislead the court. The court has inherent power to order, to protect itself and to prevent an abuse of the process and discharge the rule nisi and refuse to proceed further with the examination of the case on merit. If the court does not reject the petition on that ground, the court would be failing in its duty. In fact, such an applicant requires to be dealt with for contempt of court, for abusing the process of the court. So here is a case wherein the Supreme Court found that somebody is trying to abuse the process of the court. It's not disclosing all the facts properly, distorting the facts, trying to mislead the court. And the court has the power to deal with such litigants. What is that? Contempt of court for abusing the process of the court. So if a litigant who is supposed to come to approach the court with clean hand is coming with dirty hand, should the court not deal with that person fairly? Now again, in Dilip Singh versus State of Uttar Pradesh, the Supreme Court said, for many centuries, Indian society cherished two basic values of life, Satya and Ahimsa. Mahavir, Gautam Buddha, Mahatma Gandhi guided the people to ingrain these values in their daily life. Truth constitutes an integral part of justice delivery system, which was in vogue in the pre-independence era, and the people used to feel proud to tell truth to the court irrespective of the consequence. So prior to independence, the situation was people were ready to go to jail but for truth. However, post-independence, there has been a drastic change in our value system. There has been a drastic change in our value system. The materialism has overshadowed the odd ethos and the quest for personal gain has become so intense that those involved in litigation do not hesitate to take shelter of falsehood. So the court is reminded of a fact that just for personal material gain, just for personal gain, people are taking shelter to falsehood, misrepresentation, suppression of facts in court proceeding. So people are suppressing material fact, taking shelter of falsehood, misrepresentation in court proceeding. In the last 40 years, a new creed of litigants have cropped up. Those who belong to the creed do not have any respect for truth. They shamelessly retort to falsehood, unethical means for achieving their goals. Now, people are lying to the court. People are taking shelter of falsehood, suppressing material fact, and polluting the streams of justice system. And henceforth, the courts must deal with those litigants appropriately. In order to meet the challenge posed by this new creed of litigants, the court have from time to time evolved new rules. And it is now well established that a litigant who attempts to pollute the stream of justice or touches the pure fountain of justice with tainted hand is not entitled to any relief, interim or final. So if you come to the court with an attempt to mislead the court, taking shelter of falsehood, trying to pollute the streams of justice, then the court will not give you any relief based on this fact alone. Based on the fact that a person has approached the court with bad motivated thing in his mind, the court will not give you any relief, whether interim or final. I hope that this particular thing is clear to each and every one of you. I hope and I believe that you guys are understanding. So you might get these kind of passages. Okay, I'm reading a particular passage from a judgment. So I hope that you guys can get, if you get a particular passage like this, you will be in a position to understand what the passage talks about. Or if there are questions based on this passage, you should know how to deal with that passage. Now, what are those directions that the Supreme Court finally gave? Number one, details and copies passed in earlier bail application filed by the petitioners, which have been decided. Now, some people are not filing copies of how many, कितने bail application आपने move किया था, कुछ नहीं, और झूठ बोले जा रहे हैं, because for getting bail. Details of bail application filed by the petitioner, which are pending either in the court or in the lower court or in the higher court. And if not in pending, a clear statement to that effect has to be made. So when a person is coming to the Supreme Court asking for a bail, he must give details of earlier orders passed in all the bail application filed by the petitioner. In case it is pending, where is it pending, which court, what are the present orders that are passed by those courts, everything. So there has to be a full disclosure from that individual who is asking for certain relief. So a person who is coming to the court, must give details about every aspect, every factual aspect of his case. Just because people are not doing it, people are playing hide and seek with the game, using falsehood, using suppressing material facts from the court, और ऐसे करके एक कोर्ट से एक ऑर्डर लेना है. नहीं, ये तो जस्टिस सिस्टम तो नहीं है. जस्टिस सिस्टम मतलब आप सही चीज बोलोगे, आप सही लॉ जज साहब को दिखाओगे और जज साहब आपको आपका फैक्ट्स के अनुसार, आपका लॉ के अनुसार, जो भारत का लॉज है उसके अनुसार जजमेंट देते हैं। इधर लोग क्या कर रहे हैं, झूठ बोल रहा है, कुछ फॉल्सूट कर रहा है, कुछ मैनिपुलेटिंग फैक्ट्स कर रहा है, लाइज बोले जा रहा है। इसके लिए क्यों? जस्ट टू गेट मटीरियल बेनिफिट, जस्ट टू गेट एन ऑर्डर। नाउ दैट कैनॉट बी अ प्रॉपर जस्टिस डिलीवरी सिस्टम। और जज लोग क्या कर सकते हैं? अगर झूठ चीज आप जज के सामने दिखाओगे, जज तो वही बिलीव करेगा ना। इसमें तो जज साहब का तो कोई कसूर नहीं है या दोष नहीं है। तो आपको समझना पड़ेगा क्यों ये सब डायरेक्शन दिया गया था इस पर्टिकुलर जजमेंट में। दूसरी बात, रजिस्ट्री ऑफ द कोर्ट शुड एनेक्स ए रिपोर्ट कि कितना बेल पिटिशन पेंडिंग है, एंड देयर हैज टू बी अ पर्टिकुलर सिस्टम दैट हैज टू बी फॉलोड ना। जब कोई बेल पिटिशन आता है तो कोर्ट का जो रजिस्ट्री है वो भी एक रिपोर्ट फाइल करेगा कि कितना कितना, कौन सा हाई कोर्ट में क्या कोई बेल पिटिशन पेंडिंग है, ट्रायल कोर्ट में क्या कोई बेल पिटिशन पेंडिंग है, इसके बारे में भी एक रिपोर्ट देगा कोर्ट का जो ऑफिस है। इट इज द ड्यूटी ऑफ द इन्वेस्टिगेटिंग ऑफिसर assisting the counsel, the lawyers, to apprise him of orders if passed by any court insofar as bail application relating to that crime is concerned. And the lawyers for the parties have to conduct themselves truly like officers of the court. Now, lawyer लोग भी कभी कभार कुछ भी बोल देते हैं, ये भी गलत हो। तो एक लॉयर का भी एक ड्यूटी है, क्योंकि एक लॉयर तो इज एन ऑफिसर ऑफ द कोर्ट, सो इट इज ऑल्सो द ड्यूटी ऑफ द लॉयर टू अप्राइज द कोर्ट ऑफ द फैक्ट दैट समथिंग इज पेंडिंग, समथिंग इज नॉट पेंडिंग। टेल द रियल ट्रूथ बिहाइंड द केस। इफ यू टेल द ट्रूथ यू विल गेट a proper justice, and if you hide and seek, use falsehood, आज शायद फॉल्सूट से कुछ ऑर्डर मिल गया, कल नहीं मिलेगा। तो ये सब डायरेक्शन सुप्रीम कोर्ट ने इसी पर्टिकुलर इशू में दिया था, जब देखा उनके सामने कि काफी लोग इज यूजिंग दिस काइंड ऑफ फॉल्सूट एज अ ट्रिक टू pollute the streams and the fountains of justice. The streams and the fountains of justice. Am I clear? Everyone? Is that clear to everyone? Any question? Any question? Okay. So guys, फिर से एक रिमाइंडर, जो लोग अब तक स्लैट का मॉक टेस्ट नहीं दिए हैं, please go to the description box below. There is a link that is provided. Between the 22nd of Jan, that is yesterday, it has already started, till 28th of Jan, we are coming with this SLAT mock test, symbiosis law aptitude test, free of cost. It is free, एक पैसा नहीं लगेगा, बट आप देख सकते हो कि कैसे क्वेश्चंस आता है ये सब मॉक टेस्ट में। So do not forget SLAT mock test 22nd Jan to 28 Jan, free of cost. Link is there in the description box below. Those of you who are planning to start, those of you who are planning to start their other law entrance examination like Jamia, Maharashtra CET, then you have SLAT. So you have various other examination apart from CLAT and ILET. If you are preparing for these or CUET, and you are wanting to talk about your difficulties, please go to the description box below and a link is shared in the chat box itself. Talk to our counselors. If you wish to talk to us, let us know. We will talk to you and tell you how to start your other law entrance examination preparation. BYJU'S Exam Prep brings to you CLAT 2025 Legal and GK Booster Series every Sunday 1 p.m. and 3 p.m. This is a very important announcement. Every Sunday 1 p.m. and 3 p.m. starting on the 7th of January, live on our app, we are coming with this legal and GK booster series. Do not miss even one episode, because we will tell you what to study, what not to study, how to perform better in your CLAT 2025. BYJU'S Exam Prep brings to you CLAT 2024 टेस्ट सीरीज. आप अगर स्लैट महाराष्ट्र सीईटी देन जामिया का एग्जाम का तैयारी कर रहे हैं, यू कैन एनरोल योर सेल्फ फॉर क्लैट 2024 टेस्ट सीरीज. इधर 15 ओलेट का मॉक हम लोग देंगे एट a very cheap price. So get it now. Unlimited access to all our mock tests. And if you do these mock tests, believe you friends, you will be in a better position than ever to crack these examination, because you should know कैसे कैसे questions आते हैं. Mock tests do help you in leaps and bounds in understanding what is your strength, what is your weakness, your preparation strategy, and everything. So hurry up and get it now. BYJU'S Exam Prep brings to you CLAT 2025 comprehensive course. 380 hours of live classes, 300 plus recorded videos, 55 mock tests, practice question, sectional test, study material, doubt resolution, and the CLAT Ignite magazine. So start early. So CLAT examination, CLAT 2025 is scheduled to happen in the first week of December 2024. So you have around 10.5 months for your preparation. So since you have around 10.5 months for your preparation, it is very important that you should know what to prepare, how to prepare, and when to start. Start early. अभी से पढ़ाई चालू कर दीजिए, क्योंकि एंड टाइम में आपके पास शायद उतना टाइम ना रहे. So guys, with this we come to the end. But before I say tata goodbye, do subscribe to our YouTube channel if you haven't by now. Follow us on Instagram. Like our Facebook page. Join our Telegram channel. Very important, because we share a lot of things in our Telegram channel. And do download our BYJU'S Exam Prep app, because a lot of material, a lot of stuffs are given free of cost in our app. So guys, with this we come to the end of this session. Thank you very much. Do like and subscribe to our channel and like this session. Share this session with your friends. Do share this session with your friends, guys. Okay. So I hope that the judgment that I did discuss with you today, you have understood. And if you guys have any doubts, any queries about anything, the chat box or the comment section is definitely open. Do comment. I will reply to you. Thank you very much. God bless you. Stay home, stay safe, stay healthy. Bye-bye. Take care. Good night. See you. Bye-bye. Thank you.